Good morning, everybody. I think that I have the envious task of trying to manage this, what I feel can be the most exciting session of the entire forum. So, as we know, this is going to be presented by Michael Harris. Michael is a member of the Tapia House Group. He is a social scientist by training, and he's a columnist with the Express. So, and I think we all are very familiar with his writings. The topic this morning, State of Emergency and the Rights of the People. As an attorney at law, I can carry on about this for the entire day. And so I have to restrain myself, and I certainly will have to restrain my comments when we come to the discussion part of it. So I would like to have Michael take the floor now and tell us exactly how he's going to approach it, and I think it will be a very stimulating and exciting discussion. So I take you over to Mike.
Thank you, Mr. Theodore, Chairman. Good morning or good afternoon, brothers and sisters. Is we still morning? I want to do something that is very ought to be frowned on. To object to something my own chairperson said. I don't think my topic is as exciting as local government. We are existing right now under a state of emergency, and I know for everybody there are issues about it. In fact, since the state of emergency was declared, the debate seems to have centered on two issues. The first issue is whether the state of emergency is working, or to put it another way, is it achieving the stated objectives for which it was implemented. The other issue has to do with whether it was necessary at all to call a state of emergency, or to put it simply, the credibility of its justification. Now, those two issues are not exclusive, but they can be discussed separately. And both of them are of tremendous importance. A state of emergency is not a step a government in a democratic country ought to take lightly. And I want to stress that term, a democratic country. We will come back to that in a while. What a state of emergency always involves is an abrogation or derogation, in part or in whole, of the rights of the people. And in a democratic country, I will say a lot more about that in a while, but in a democratic country, that is something that must not be taken and cannot be taken lightly. So, we are currently in a state of emergency, and to my mind, it is good that there has been from the day one a public debate about these two sides of the issues, and obviously our discussion here today seeks to continue that debate. However, I do not propose to deal with the first issue as to whether the state of emergency is achieving its stated objectives. Except perhaps to refer you to the article written in last Sunday's Express by Martin Daly, with whose views on that particular issue I entirely concur. I would only add to that when a state of emergency is misused, as I think this one has been, not only does it serve to exacerbate the very problems that it is meant to deal with, but it raises as well some deeply troubling issues about the procedures which we have enshrined in our Constitution for declaring such a state. But we will come to that a little later. So what I want to focus on is the second major issue of the debate, whether the state of emergency was justified. But I would want to, those people who have argued on this issue have proceeded from a fairly narrow point of view. Essentially, they have declared that it was unnecessary because the stated objectives could have been achieved through other legislation and other measures such as better policing and so on and so forth. Clearly, the stated objectives had to do with, as our Prime Minister put them, one, taking the criminals off the street, getting the guns, and disbanding the gangs. All of which, of course, relate to the crime situation that we have. I leave it up to you to determine whether those stated objectives have been achieved, but those who oppose the state of emergency on those grounds argue, of course, that it was not necessary to have a state of emergency to achieve that. I do not want to deal with the present in terms of that issue. It is possible to take the discussion, and perhaps we should take the discussion beyond our present circumstance. For by doing that, we may come to a better appreciation of the enormity of the act of declaring a state of emergency, and be in a better position now and in the future to assess and possibly make a determination as to just what set of circumstances may make the declaration of a state of emergency justifiable, if any at all. The first point, therefore, I want to make in this regard is that the issue of the justification for a state of emergency has a long history of debate and discussion among political and legal theorists. So I could understand why Mr. Theodore is champing at the bit. And I am not going to engage this morning here in an academic discourse, but I think it is important that we have some appreciation of the central issues of these theoretical and philosophical debates, because those issues lead us to make some determination for ourselves in terms of the practical situation in which we find ourselves. So that to do that, I will have to call a few authors' names and cite a few passages, and I ask you to forgive me for that. I will try to keep them to a minimum. One question which has been central to this theoretical and philosophical debate on the legitimacy and justifiability of a state of emergency can be posed as follows. Can a nation in which a state of emergency is declared still be considered to be subject to the rule of law and still be considered to be a democracy? Let me repeat that. Can a nation in which a state of emergency has been declared still be considered to be subject to the rule of law and still be considered to be a democracy? Now, in every country, every point of time, we must recognize that there are moments in the life of a country, a society, a polity, when the threat to its integrity is so grave that extraordinary measures are called for. That cannot be gainsaid. I mean, most of our Constitution talks about state of war, if Grenada would attack or something. Talks about natural calamity, acts of nature of vast consequence. And it talks about states of public disorder that threaten the security and stability of the name. Obviously, we are not in war, and have not had a natural disaster since the last election. But the question really is whether the threat of crime was grave enough to constitute an immediate, as they say in the literature, clear and present danger. But that is not the key, because we recognize that nations, whether in our case it was so or not, we recognize that countries at times face grave threats to their integrity that require extraordinary measures. We recognize that. In fact, the European Convention puts it this way: in time of war or public emergency which threaten the life of the nation, any contracting party may take measures derogating from its obligations under this convention. Right? In times of war or public emergency which threaten the life of the nation. So that we recognize that there will be instances and times when extraordinary measures have to be taken. The question, and I repeat it, and it is not the theoretical and philosophical, but it is not academic, is can such a nation still be said to be operating under the rule of law and be a democratic country? And I want to remind you that the device we know as a state of emergency has a very long pedigree. Under Roman law, for example, when the Roman Senate was alerted to a situation that seemed to threaten or compromise the Republic, they pronounced what was called, and forgive my Latin, a senatus consultum ultimum. The senatus consultum implied a decree by which one declared what they called a tumultus. That one is very close to the English word. And a tumultus is in effect a state of emergency caused by internal disorder or insurrection. And the automatic consequence of declaring a tumultus was the proclamation of a justitium. A justitium literally signifies to arrest or suspend the jus, that is, the legal order. A justitium signifies automatically to arrest or suspend the jus, that is, the legal order. If we move a little forward in time, we have the English political philosopher John Locke, who argued that the power to act, and note carefully, the power to act according to discretion for the public good without the prescription of the law, and sometimes even against it, is that which is called prerogative. The power to act according to discretion for the public good without the prescription of the law, and sometimes even against it, is that which is called prerogative. I will come back to that in a little while. Coming forward even further, when Adolf Hitler was made Chancellor of the German Reich, his first act was to declare a state of emergency and suspend the individual liberties and rights which existed under the Weimar Republic. And for the 12 years of the Third Reich, that state of emergency was never revoked, so that it was a permanent state of emergency, the Third Reich. I mention these things because the device of a state of emergency by itself is not the issue. But the Roman state, the Roman Republic, was not a democracy. In fact, as you would know, the Romans weren't very fond of democracy. Borrowing from their Greek friends, they considered it the worst form of government. John Locke was writing at a time when England was still ruled essentially by an absolutist monarch. So there was no question of democracy. And when John Locke talked in that quotation about the prerogative, he is really referring to the prerogative of the king or the sovereign. And what he is saying is that the king or sovereign has the right for the public good to suspend the rights of the people temporarily, or to ignore or even act against the law of the land. for the overarching quote-unquote good. Incidentally, in an advertisement, I think, I have not really heard any one of the spokespersons make it. In an advertisement, you hear the voice of our Prime Minister saying that the state of emergency is a temporary suspension of rights in order to restore full rights. And it is, in fact, the same argument that Locke uses. And I find that very interesting because Locke was speaking in the context of an absolutist monarchy. Again, we'll come back to that a little bit. So, the point I'm trying to make is that a state of emergency only presents theoretical problems, although they may always present operational problems, but theoretical problems in the context of a country that claims or subscribes to the rule of law and claims to be a democratic country. We might better understand the essence of this problem if we consider the words of the American Declaration of Independence, which states, inter alia, quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and that amongst these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Powerful words, huh? Written by powerful men at a hell of a time in history. They were revolutionaries, of course. Right? This was their justification for throwing off the yoke of English colonialism. Right? But it is also deriving from the French Revolution a powerful statement of the democratic ideal, that they are endowed by their Creator with unalienable, note the word, unalienable rights. Life, liberty, and the pursuit of happiness. And that to secure those rights, governments are instituted among men, deriving their just powers from the consent of the governed. If we take those words as a definitional framework of democracy and add to it that the security of those rights is effected through law and in most cases is enshrined in constitutions, then the question has to be posed: how can a state of emergency, which, whether through suspension, abrogation, derogation, infringe on those supposedly unalienable rights, be compatible with or justifiable in a democratic polity? At this point, I want to come back to our situation and address the words of our esteemed Chief Justice, for whom, let me say, I have the greatest of respect. In his address at the opening of the new law term, he argued that those provisions of the Constitution that protect and preserve the fundamental rights of the citizens have not been suspended or pushed aside, but there has only been some temporary and limited restriction on the exercising of such rights. You remember that? Well, first of all, no matter how temporary or limited they may be, any restriction on the normal quantum or application of the rights of the citizen is an infringement of those rights. That goes without saying. But our Chief Justice's argument is more subtle and profound than that. What he is essentially arguing is that because the power to declare a state of emergency is located within the Constitution, and that the state of emergency was declared in accordance with those constitutional provisions, then ipso facto, the state of emergency is constitutional. No, a very powerful argument, and you cannot dismiss it. But what you see is really happening here, and perhaps it is because he is quintessentially a legal mind and not a political one. What is happening here, you see, is a confusion between legal and legitimate. His argument is really saying that the state of emergency is legal, but nobody ever questioned that. The issue is whether it is legitimate. Constitution with a small c or constitution with a big C. Whether the rule of law that we're speaking about that is abrogated or derogated refers to those fundamental or substantive principles of democracy, or whether the rule of law merely refers to where there is legal warrant for an action. Right? But there is an even more important exception to our esteemed Chief Justice's argument, and it is simply this. If the Constitution can contain provisions for the temporary and limited infringement of the rights of the people, what prevents the Constitution from making provision for the prolonged abrogation of those rights? Constitution with a small c now. And if by some unfortunate happenstance, which in our context is what, 2/3? Or whatever it is, 3/5 in some cases, 2/3 in others. Right? Some unfortunate happenstance that were to happen, would such a state of emergency be still constitutional? We are not there, far from there. But it is important to ask the question in order to understand the paradox that our Chief Justice finds himself in. Not only himself, but the whole legal establishment. With all due respect. Right? Because what is being countenanced is the legal abrogation of the rule of law. A conundrum, if you will. So, let me return therefore to the issue of the American Declaration of Independence and make one final statement on that. Government, it states, derive their just powers, and note the word just. There can be unjust powers, from the consent of the governed. What this is in effect saying is that in a democratic polity, sovereignty resides with the people. This is very different from Locke. This is very different from the Roman Senate. And we won't even mention Mr. Hitler. In a democratic polity, sovereignty resides with the people. There is no state. There can be no state apart from that which is constituted by the will and the wishes of the people. Indeed, from the moment you can recognize the existence of a state as an entity apart from the people, the democratic principles cease to apply. To protect the state, therefore, by a measure which abrogates the rights of the people, may be called many things, but it cannot be called democracy. So, let me step back a minute and recap. In the life of any nation or country, there will be times and moments of such grave emergency and exigency and danger to the integrity of that country, state, or polity, when extraordinary measures are demanded and required. However, a state of emergency is such an extraordinary measure, and the question I posed at the beginning is, can you still have, in a nation where a state of emergency has been declared, can that still be considered a nation governed by the rule of law and a democratic country? Right? It is an issue, a question that has exercised theorists, legal and political, for many, many centuries, decades. Locke wrote in the 16th or 17th century. But it would be no surprise to find out that within the last decade, it is a topic that has risen once again to prominence among scholars, particularly in the United States of America, where ever since 9/11, the government, to protect the public good, I always go back to Locke, has introduced some of the most draconian legislation imaginable. It started in October of 2001 with the Patriot Act, and then in November of that same year, Bush the president, introduced executive orders, which are still occupying the Supreme Court in the United States today, Those executive, under the Patriot Act, the government had the right to arrest and detain any alien who they thought might be a danger to the state. But the Patriot Act demanded that after 7 days, they be brought before the court. Bush's executive order of the November of that year removed even that pigskin of legality and created something that legal scholars are still wrestling with: non-persons. Right? These aliens, and sometimes the aliens were from Afghanistan, caught in the war there, were not prisoners of war under the Geneva Convention. They were not aliens under the Immigration Act of the United States. They were nothing. Right? And Guantanamo became a piece of land outside of this planet Earth. And no one had any jurisdiction there except designated people of the state. So that for the Americans, this has been a really serious development, because, as you know, there are those who understand perfectly well that if they come for the communists yesterday, and they come for the Jews today, and they come for the whatever N-word, when they come for me, who do I turn to? So that this is these, and while I said that they are theoretical and philosophical issues, they are about real life. We are under a state of emergency. And scholars have been trying to devise solutions to this for a long time. One scholar, Clinton Rossiter, and to tell you how difficult these issues are, Clinton Rossiter, in a book entitled, and this gives away his solution, book entitled Constitutional Dictatorship, right? Written back in 1948, concluded, and how similar to Locke and how similar to Bush and his apologists, no sacrifice is too great for our democracy, least of all the temporary sacrifice of democracy itself. No sacrifice is too great for our democracy, least of all the temporary sacrifice of democracy itself. So this author at least answers the question, can a nation in which a state of emergency is also a democracy, very, very clearly. The author, however, tries to provide the rationale for constitutional dictatorship, as he put it, by saying that the democratic system, the constitutional state, is designed to function during peace and is often unequal to the exigencies of a great constitutional crisis, and that the system of government must be temporarily altered to whatever degree is necessary to overcome the peril and restore normal conditions. The logical problem in that solution, there are other problems, but the logical problem in that solution is who is going to force the constitutional dictator to restore normal conditions? Another scholar, Bruce Ackerman, in his essay, The Emergency Constitution, note all these terms, right, to try to deal with the paradox. Starts by claiming that we need new constitutional concepts in order to avoid the downward spiral in protection of civil liberties. This is an American writing post-Patriot Act. And he proposes one such device which he calls a supramajoritarian escalator. Supramajoritarian escalator, which basically says that the requirement that a declaration of a state of emergency requires legislative endorsement within a very short period of time, and thereafter has to be renewed at short intervals, with each renewal requiring the approval of a larger majority of legislators. So if you go for the 15 days, you do it on simple majority. You go for your first 3 months, 3/5. The next time you go total. Right? But anyhow. Right? And there have been other, for example, one author recommended that immediately with the declaration of a state of emergency, there would come into being a special review tribunal that had the power to review all acts committed by an executive during a state of emergency. Immediately. In other words, you cannot declare a state of emergency without bringing that tribunal into being. But the tribunal is a review tribunal, which obviously means that it is reviewing post facto the acts of the executive. Right? So that I wanted to bring this kind of level of debate and discussion. I know it is not the kind of exciting hit them and lash them debate about our current state of emergency. To let you understand that these are heavy and really complex issues that we are dealing with and should not be taken lightly. And that the imposition or declaration of a state of emergency is not a step to be contemplated for minimal gains or reasons. When you talk about threatening the life of the nation, that must be exactly what is happening. I want to end with a quotation from another author that says the following, because I think it gives some idea of where the nexus of the paradox and the problems lies. He says the very definition of the term state of emergency is complex, since it is situated at the limit of law and of politics. According to a widespread conception, the state of emergency would be situated at an ambiguous and uncertain fringe at the intersection of the legal and the political. The task of defining its limits is nevertheless nothing less than urgent. What are the limits of a state of emergency? Very important. And indeed, if the exceptional measures that characterize a state of the emergency are the result of periods of political crisis, and if they for this very reason must be understood through the prism of politics rather than through the legal or constitutional prism, then they find themselves in the paradoxical position of legal measures that cannot be understood from a legal point of view, and the state of emergency presents itself as the legal form of that which can have no legal form. I am sorry if I have no answers to present to you. Right? But we must continue to debate these issues, and the debate is very important. For in the final analysis, it still remains that eternal vigilance is the price of freedom. Thank you very much.